Hello, welcome to Rush to Judgment with Jessica. Good morning, good afternoon, good evening, from wherever it is you are coming from on this fine, fantastic day. Cold day here. It's a super duper cold day here. But I hope wherever you are warm, toasty, cold if you like it, rainy if you like it, sun shining if you like it. Whatever floats your boat. Billy Goat. So, anywho, how's it going? How is everybody? Is everybody okay? Everybody doing well? That's good. Okay. Well, we are getting right into it. Day six of the Alexander Jackson trial. I am super excited. This seems to be a short day, so I feel like this is the last day of testimony. I'm going to go out on a venture and say this because there's only a day 7 left. And so I'm going to say day 7 is like closing statements, and then it goes to the jury. So that's my guess. I swear to God. I swear to God, 2 minutes in, I press record and I get a text message from my kid. I'm not even joking. Like, I sat here and contemplated, do I press record and just start because she's in bed? She's in bed. Or do I go back in and ask her, do you need anything before I start? But she's in bed. Love it. Anyway, Alexander Jackson, he is on trial he is being charged, I should say. Because in this world, we don't know. We don't know if it's still allegedly in this world. He's being charged with 3 counts of first-degree murder in the murders of his mom, dad, and younger sister. He claims there was let's not do that, puppy dog. There's a puppy down here. There she is. Say hi, puppies. Anyway, he claims there was an intruder in his home who did the killings of his mom and dad and his younger sister. And then he fought with said intruder. And during this altercation, he was shot in the foot. Believe, yes or no. That's up to the jury. But it is also up to the state to prove beyond a reasonable doubt, without any plausible explanation, that anything else could have possibly happened, and that he most definitely was the one that committed this crime, and there could have possibly been no one else that committed this crime. Personally, I don't feel like they did that. I believe there is plenty of doubt, plenty of reasonable doubt that something else could have happened. I believe there was a lot of shitty investigation work done. So far, I have yet to see anything groundbreaking and revolutionary, and the state's case is over. We are in the defense's case in chief. So we are now hurrying. We're now hurrying from the defense's witnesses. So, yeah. So why don't we just stop chit-chatting? And also, just a reminder that if you like what you see here, you can go ahead and like and subscribe and put a stop that. Oh, good God. Sorry. Dog is roaming. You can put a comment in the comment section And then you can hit the notification bell and you can see whenever I post anything new, and keep up with all of said videos that I put out. Yes, because we all know that you want to follow and you want to watch everything that I have to say, because everything I have to say is so important. But I also want to remind everybody that this is for entertainment and maybe a little educational purposes only. Maybe you haven't watched this trial and maybe you want to watch it with somebody that might entertain you just a little bit, or maybe you have the same thoughts as I do in some different areas. I don't know. Or maybe you have the opposite thoughts that I do. Who knows? Whatever. But yeah. So, like, subscribe, comment, do all of those things. But while you do that, let's watch what happens in day 6. I don't know how long it takes them to start up. Just sitting there. Oh, now we're getting up and leaving. Gosh dang it, Judge. There's no sound. They're not talking. If they were talking, his little red light would be on his micro.
Can you spell them both, please? Can you spell them both, please?
Garrett Barton.
All right, thank you, Mr. Barton. Ms. Garner, sorry.
Thank you, Your Honor. Good morning, Mr. Barton.
Good morning.
Can you tell us how old you are?
I am 19 years old.
And where do you reside currently?
Cedar Rapids, Iowa.
I was
And are
the
you currently
other
working?
attorney.
Where do you work?
Work at Menards
How
on
long
the
you-
southwest side.
Sorry. How long have you worked there?
3 years, I believe.
And are you familiar with this gentleman next to me?
I am.
How long have you known Mr. Jackson?
Since 2015. So, 7 years, about.
Where did you guys meet?
Scouts in Troop 766.
I'm sorry, can you repeat that?
Scouts in Troop
Trout.
766.
So you guys met as a scout
Trout.
members,
Scout.
and that was in 2015, you said?
Roughly, yes.
So how old do you think you would have been when you met him?
About 12 or 13.
How often do you think you had contact with Alex?
At least once a week at the scout meetings, up until the Yellowstone trip.
And did you have, was that up until the Yellowstone trip? Is that what you said?
Yeah.
And did you have any other contact with Alex outside of Scouts?
Very little.
So let's talk about, well, let me talk about the Yellowstone trip. When did that occur?
It occurred in the summer of 2016, I believe. We went to Yellowstone for, I believe it was 21 days. We were backpacking pretty much most of the whole time.
How many other Scout members were with you?
Don't remember an exact number, but we had 2 different groups. Our group was the backpacking group, and we had, I want to say 12 people. I don't remember an exact number.
And then did Alex play any particular
That's
type of role on
attorney
that trip?
throughout the whole thing.
Not that I remember.
Her grandma died.
He did carry a lot of the dromedaries, if I remember correctly, which was what we used to carry water into the Yellowstone Park.
What type of activities did you do other than backpacking while you were on that trip?
On the way there, we stopped at the KOA campsite right outside of Mount Rushmore. We camped there for the night, did some hiking around there, and then on the drive, we didn't really stop anywhere too much. And then on the way back, I think is when we stopped and did some whitewater rafting.
Did you and Alex interact often on that trip?
Yeah, he would bring these choose your own adventure books, and we do those on the car ride.
What was included in those books?
Just like medieval adventure stuff.
Medieval adventure stuff. Did they
Were you able to
play
earn any
Dungeons and
badges? Were
Dragons?
you and Alex
It's
able
the
to earn any
Satanic
badges on that
Panic.
trip?
From
Oh,
what I remember,
no.
we were able to work towards different hiking badges. Trying to think.
Stop it.
We were able to work towards the hiking badges and some requirements for other ranks we were trying to meet in the scout program.
Would you say that you and Alex were on the same path, badge-wise, to becoming an Eagle Scout?
He was a little farther along than I was, but we definitely
Older.
were. At that point, it looked like we were going to get Eagle, yes.
Did you guys start Scouts at the same time?
He started a little before me. I don't know an exact point in time, but I was in a different age group than Alex.
And were you involved in a home restoration project that Alex led?
Yes, I was.
And can you tell me what that involved?
Mainly what I did
Hi, Colleen.
on his Eagle project was we went around and restored this historic house, and I ended up painting most of the trim along the top of the walls in each of the rooms.
And was that Alex's project that everyone helped him on?
Yes.
Did you ever meet Alex's parents?
I've met his mother a few times. She would always help out at the scout meetings. She always helped with cleaning up afterwards. His father I only met once, and that was at the Eagle Project. I didn't really get a chance to talk to him, though.
Did you ever see Alex and his mother interact?
A few times at the scout meetings.
What did you observe about their relationship?
Always kind and respectful. Never really raised his voice at his mom. There were some smart aleck remarks, but I can't pinpoint an exact phrase.
But for the most part, respectful?
Yeah.
Did you ever see him be unruly to his mother?
No.
Ever mean to his mother?
Nope.
Did you ever notice him being disrespectful to his father?
No.
Jeez. I don't know that anybody could ever say that about either one of my children.
And on all these occasions that you were around Alex, did you ever see him act violent towards any other scout members or anyone?
No.
Any type of behavior?
No violent behavior. We were competitive at like card games, but nothing like threat-wise or physically hurting anybody.
Were these card games on the Yellowstone trip?
Yellowstone and other scout meetings, yes.
Did you ever see him get angry with any other scout members?
No.
So anything that you saw in the competitive nature was purely for fun?
Yes.
I don't have any further questions.
Mr. Scheer, cross-examination? Just a couple, Your Honor. Good morning, sir.
Good morning.
How are you today?
Pretty good.
My understanding is the last time that you had any contact with Mr. Jackson was back in 2016. Is that correct?
That is incorrect. Right at the end of his scouting career right at the end of my scouting career, we were kind of doing loose communications outside of scouts. It was just hey, how's it going? Good, and that kind of stuff. Nothing like hanging out. But 2018 would be the last time.
Okay, so the last time that you actually had any type of communication by electronic or verbal was around 2018, correct?
Correct.
But it sounds like the last time that you guys physically saw each other was around 2016?
Correct.
And so in 2021, it's safe to say that you hadn't had any contact either by text, phone, email, or anything for almost 3 years with Mr. Jackson, correct?
Correct.
And by then, you don't know how his relationship was with any of his family members, correct?
Correct.
And that you were never been to his home either, correct?
Correct.
Thank you, sir. No other questions. Any redirect?
All right. Mr. Barton, you may step down and are free to go. Thank you, sir.
Thank you.
Fantastic.
Okay.
That was underwhelming. Are we going to get family members? Character witnesses? Can we get any of that? Let's just stare at Judgement Cutie. Scratch his nose, mess with his beard.
Good morning, sir.
Fidgety,
Can I have you
fidgety.
come up and take a seat to my far left, if you would? You can go ahead and have a seat. And I'm not sure we picked that up for the record. Who's the state's next witness?
This is Jared Wacker, Your Honor.
All right. Mr. Wacker.
Whacker.
A couple things. First, that microphone's live, so you can move it around to make it suit you as best as you can.
Closed captioning.
Second, I'm going to go ahead and swear you in, so you can please raise your right hand. Mr. Wacker, do you swear or affirm that the testimony you'll be giving in this matter will be the truth? Yes, I do. Okay, you can put your hand down. And for the record, sir, can you please give us your first and last name and spell them both?
Jared Wacker. First name is
Oh, that is
J-A-R-E-D.
such
My last name is
an
Wacker,
unfortunate
W-A-C-K-E-R.
to have your last name as
Thank you, Your Honor.
Whacker.
Mr. Wacker, how are you employed? I am a band director in the Cedar Rapids School District. Are you currently at Washington High School? Yes, I am. And did you teach band anywhere else before Washington? Yeah, I was at Kennedy High School for 9 years. And how long have you been at Washington High School? I'm in my second year right now. Okay. What was your position at Kennedy High School? I was one of 2 band directors there. What were your responsibilities as a band director at Kennedy High School?
Can you go
Kennedy, I
around
co-directed
the
the
other way?
marching band, shared that with the other band director there, and
From
helped
which
students prepare for all-state auditions in the fall. And then after marching band ended, we kind of split things up. I directed the Wind Symphony at Kennedy, which was the top audition concert ensemble there, and then also directed the top jazz band. So Wind Symphony, is that wind instruments? Yes, these are band instruments. Yep. The ones you blow into? Yes,
Oh,
most
for
of them.
God.
Some of them you hit as well. So I'm not trying to be too technical there. During your time at
wind
Kennedy, I'm
instruments?
acquainted with Alexander Jackson. I did. And when
I
did you
didn't
first
know
meet
that.
Alex? I met Alex
Wind
his
instrument
freshman
be-
year, 2015. Were you his band teacher? Yes, I was. For how long were you Alex's band teacher? For 4 years. What instrument did Alex play? Alex played the flute. And how was Alex involved in the band program? Alex, I believe his first year, he opted to not do marching band his freshman year. He played in the freshman concert band. Freshmen have the opportunity to not do marching band that first year. So I believe he opted to do that. And then did one of the concert bands the second half of the year. And then after that, he did marching band for 3 years. Each fall, and then was in symphony and ended. And the Wind Symphony is the top concert band? Yes, it is. It's an audition group. You have to audition to be a part of it. And it's usually the higher achieving students that have a little bit more ability or have put in a little bit more time on their instruments. So those were the courses that you taught then? Yes. And is band a
Utilizes
full-year
air
course?
wind to produce
Yes,
musical
students, when they
vibrations.
sign up for band, they're registered for 2 semesters of it, so for the full year. Can you tell us a little bit what the schedule is like for
Play
students
the
in marching
flute.
band? Yeah, marching band, it's
I
pretty
am
intense,
getting
pretty
winded.
intense, excuse me. It starts before school actually begins in the fall. We have a few weeks of rehearsals in early August where the students will come in 8 o'clock a.m. and they'll be there till about 4:30. And so lots of rehearsal time before school starts. Once school is in session, then we see the students, or we saw the students starting at 7:30 a.m. and it would go through first hour, so 7:30 to 8:45 every day for class time. And then we would also have evening rehearsals Monday nights, 6 o'clock to 9 o'clock, so 3 hours there once a week. We would play at every home game, so 5 to 7 of those in a season. And for those, again, a big time commitment, we would bring the kids into Kingston Stadium, which is where we play our home football games, to do a rehearsal before the game and then perform at the game. So that's another 4 or 5 hour commitment. And then we would do 4 weeks in a row of contests or festivals. So there would be 4 Saturdays in a row where we would be with the kids pretty much all day, 9 o'clock to about 1 o'clock the next morning.
And but going back to like before school started, were there evening rehearsals during that time too?
Yes, there were. So we would,
Different.
within like, so the
I've
first week we did
been-
morning through afternoon, 8 o'clock to like 4:30. And then typically like the second week after that happens, so like the second week in August, we would start doing evening rehearsals. So it would be more like 5 o'clock to 8 o'clock or 9 o'clock. So yes.
Did you say 8 o'clock or 9 o'clock?
Yeah, at night. Yep. Sorry.
Was that, many nights a week was that?
Harmonium is one of the pump
For that week before school
organs
started, I think we did Monday through Thursday was typical.
from
I got you.
Denmark,
That was just the week before school
from
started.
formed for the
And
first
how was
time
Alex's attendance?
It was good.
in the
was rare if he missed.
1780s.
And did he actively participate?
Like a
Yes, he did.
piano with
How would you
a
describe his work ethic?
He was a hard
accordion
worker,
thing on the back.
very polite, took suggestions very well.
Did he seem interested in the program and improving himself as a player?
Yes, he absolutely did. He worked hard at that. And he always seemed to want to do well. So he worked very hard on his instrument.
Now, were you his only music teacher?
I was not. There was another band director there that
Clarinet's
taught with me at
pretty-
Kennedy.
I
And we
had a
also would bring in
clarinet,
other like clinicians or
That's
professionals on
cool.
their instruments just to kind of help us out.
bagpipe.
To your knowledge, did Alex have a private teacher as well?
Yes.
Do you know her name?
I believe at the time it was Amy Sams was his private lesson teacher.
How many students were in the Wind Symphony?
So the Wind Symphony, being a select group, we were typically between 40 and 55 kids, depending on the year.
How many flutes?
Our smallest group of flutes would have been 4, and our largest probably 6 or 7.
How did Alex get along with the other flute players?
He got along very well within the section. We had, I think it was his junior year, we had a lot of drama within the flute section, and he actually was a very calming presence within that group.
Did Alex get any? Okay, let me strike that. Was Alex ever featured in any of the band performances?
Yeah, because he was one of our higher achieving students his senior year, and worked pretty hard. He was one of our featured soloists in our marching band show his senior year.
And did Alex participate in any band trips?
Yes. I believe we went on a trip in 2017 to Florida that I believe he participated in, and then his senior year, I believe it would have been February of 2019, he went on an honor band trip up to UNI.
What is an honor band trip?
So an honor band, it's for, again, students who
Honor
want
members of
more opportunities within band to play their instrument. They can apply to be a part of honor bands around the area. University of Northern Iowa has one, Iowa State has one, Coe College has one. So students, if they want to be a part of an honor band, what they do is they'll apply and they'll put together an application stating like all of the things that they've accomplished on their instrument. They've auditioned for this, or they've done that, or they've made this group. And then they'll give those applications to me, and I'll process them and send them to whoever's putting on or hosting the honor band. And then, like for example, UNI in this case took all of those applications they get from band directors around the area, and they'll select the top students out of those applications and put together a group that will get together and perform.
And can you tell me, was that like a Thursday to Saturday trip?
It was. That one is typically we'll leave school shortly after school ends on a Thursday, and then travel up to the University of Northern Iowa, where they'll have rehearsals that evening. And then we stay in a hotel Thursday night, and then again rehearsals all day Friday, and then we stay in the hotel again Friday night, and then rehearsal Saturday morning, followed by a concert Saturday afternoon.
How many students did you take on this trip?
It varies from year to year. I believe that year we had quite a few students go, probably around 10.
And what would that entail when you're not playing in the band? What other kinds of things did you do with the students on that trip?
We would take them off campus. I was transportation to and from the university from the hotel, so we would take them out to eat, take them back to the hotel where they could swim and relax. Yeah, that's pretty much it.
And did you have an opportunity there to see Alex interact with his other bandmates?
I did.
And how would you describe his interactions with them?
He was friendly. I never saw any issues whatsoever.
Never saw him get mad at anybody?
No.
Get in a fight with anyone?
Nope.
Did Alex try out for All-State Band?
He did. He auditioned for All-State, I believe, 3 years.
And did Alex receive any other awards or recognition for his involvement in the band program?
I know he lettered in band. He earned a band letter at least twice. I want to say 3 times probably at the end of the school year. Yeah, that's what I can recall.
I have a co-college honor band on here.
Oh, that's right. So yeah, UNI honor band, and I think he did the co-college honor band as well one time.
So how would you describe Alex's temperament in the time that you were his band?
Again, he was always polite,
Oh,
took suggestions well, which is not always the case with students. But he always did. He was always there on time. He was a hard worker, and I enjoyed my time with him.
I'm sorry, you said what?
I enjoyed my time with him.
Okay, sometimes I can't. I'm sure it's me.
Probably not.
How did Alex get along with his classmates during the whole time that you taught him band?
Very well.
Did he have a group of friends in the band?
He did. He had his group of buddies that he hung around with and got along well with.
Did he opt up for extra time in the band study hall?
Yeah. So students had the opportunity, because study hall could be kind of not conducive always to studying. We gave the students that were in band the opportunity to come to the band room during study hall. They had to sign a sheet of paper, and their parents had to sign it, and we had to give that to the attendance office. But he opted to be in the band room at least one semester, probably more than that, where he would come down and just be in the band room, and he could study there and practice and just hang out. So
Again, you tailed off
I'm
there
sorry.
at the end.
So yes, he did. He at least one semester he came down to he was in the band room for one of the periods that he had study hall, and he would be there and he would study and practice.
To your knowledge, did Alex ever get into any trouble at school?
Not to my knowledge.
Did you ever see Alex get into any fights in school?
No,
Was Alex ever sent to the principal's office or detention?
not that I'm aware of. No,
Was he ever suspended from school?
not that I'm aware of. No.
And do you know when would have been the last time you spoke with Alex?
Probably his graduation, so late May of 2019.
yes. Get ahead of that question before little Doogie Howser over there
I don't
does.
have any further questions. Thank you.
Ms. Slaughter, cross-examination?
Thank you, Your Honor. Good morning.
Good morning.
Mr. Wacker, you said that Alex had a private band instructor.
Private, yes, private flute instructor. So students who wanted to be pushed a little bit more on their instrument, they would hire an area teacher on their specific instrument to help them.
So his
if they
mom
would
and
need to
dad
typically
hired
once a
him
week,
a
usually for a half
private
hour to an
instructor.
hour, to improve their skills as a player.
On average, in 2019, how much did a private flute instructor cost?
On average, I would say anywhere from 2019, it's before COVID, anywhere between $25 to $40 a half hour. It depends on the teacher. It could be more.
And you said this was prior to COVID. Has it gone up since COVID?
For some teachers, yes.
Out of all of your students, could you fashion a guess as to how many of them were privileged enough to have a private instructor?
At that point in time, quite a few, at least the students that I worked with, probably 30 to 40%.
And that was something generally that the parents would pay for?
Yes.
Did Alex's parents show up at his performances?
Yes. I knew his mom pretty well, saw her at many of the events. Yeah.
Would you consider Jan and Melissa as supportive?
Yes.
You said the last time that you saw Alex was in late May of 2019 at the time of his graduation. Is that correct?
Yep.
Can you recall what type of grades he was getting in your class?
In my class, A's, A pluses.
Do you know what his grades looked like in his other classes?
I do not.
But in your class, A or an A plus?
Mhm.
Is that a yes?
Yes, I'm sorry.
That's okay. And you said that Alex was a hard worker
Yes.
and he was one of your higher achieving students, right?
Yes.
And he played in the honor band and
Yes.
would you be surprised to find out that his college GPA was a 1.59?
Objection, Your Honor. That calls for hearsay and for speculation.
Overruled, you can answer the question.
I would be.
1.59? Would you be surprised to find out that he was failing the majority of his classes?
Yes. Yes, I would be.
And would it be fair to say, Mr. Wacker, that a lot can change in 4 years?
Yes, I would agree with that.
Okay. I don't have any further questions for this witness, Your Honor.
Redirect?
No further questions, Your Honor.
All right. Thank you, sir. You may step down, and I believe you're free to go.
4 years. He said that was 2019. This happened in 2021.
Well, I guess, why don't you check if they're here? We don't need a break. If they're not, then we can talk about it.
It's not uncommon for young adults to do poorly their first semester, even their first couple semesters. Like I said the last time, I did really awful because you have so much more freedom than in high school. Like your teachers aren't on you. You don't have to get up and go to classes if you don't want to. You are your own you are your own person. Like college is a different beast than high school. It's not the same thing. It is not uncommon for people to fall behind. I would imagine. I don't know that for sure, but I wouldn't
All right,
imagine.
ladies and gentlemen, at this point, we're going to need to take a break. I'm not sure exactly how long it'll be at this point. So why don't we just assume a 15-minute break? May bring you back in and talk to you more, but we'll just have to figure it out. But at this point, we're on break for at least 15 minutes. I would remind you of the admonition that I've given you previously and ask that you be back ready to go shortly before 10 o'clock.
I don't know what the hell that noise was. A child, but I don't know what he was doing. If you heard a weird noise, that would be what it was. They're waiting on a witness. I like her hair much better down. Oh dear. Oh no, I can't hear shit. I wonder if his attorneys like him. Oh my goodness, it is such a long break. It's like an hour. Yep.
All right, counsel, you ready?
Yes, Your Honor.
All right, we're on the record outside the presence of the jury. We have counsel and Mr. Jackson present. Here to make a record on a couple things. First of all, I think the record reflects that at the end of the day, Friday, at some point we had on the record dealt with a potential witness noted by the defendant, Charles Gavin, and there was an objection to calling Mr. Gavin. That resolved itself over the weekend. The defendant no longer is calling Mr. Gavin, so that resolved itself. However, over the weekend, the defendant did identify another witness that to call, and Mr. Chris Lyon. And so I guess, as I understand where we're at this point, Mr. Lyon was here. Mr. Lyon is somebody purportedly who has expertise in reviewing Cellbrite data, and will testify, as I understand it, something to the effect of, will testify about the Cellbrite data on Mr. Jackson's telephone, the defendant, Mr. Jackson's telephone, and how it relates to the Ring camera in the backyard. And the state obviously just became aware of that over the weekend, and their expert came over this morning. The two experts and the attorneys met. It's my understanding at this point the defendant still wishes to call Mr. Lyon. Is that correct, Mr. Johnson?
Yes, I mean, there was no offer from the state for any sort of a stipulation, so.
And that's fine. So at this point, I guess, where are we at as far as the state's position on calling Mr. Lyon?
Your Honor, I would like to preserve my earlier objection for the record regarding this witness due to timeliness under 2.13, parent 3 and parent 4. The state's position is that the defendant had notice of what our witnesses would testify to, specifically regarding the findings on the phones. And because we weren't given the 9-day notice as required by the rule, we are objecting to this witness. I understood off the record that you were going to overrule my objection, so we did do the meeting that you referenced earlier, and the state is prepared to proceed.
And with respect to the objection, Mr. Johnson, what record would you like to make?
That this was in response to questioning by the state with Investigator Denlinger, where he was allowed to speculate in all sorts of manners outside his area of expertise, one of which was the possibility that my client had accessed the Ring app either on his phone or his parents' phones. And so we responded to that by getting a hold of Mr. Lyon over the weekend. He had the opportunity then to review the Cellbrite data, and he's prepared to testify today.
All right. Based on, I guess, my review of the minutes and having heard the evidence in this case, at this point, I do believe it was a new issue. Certainly the issue of the Cellbrite data, the Ring cameras had been an issue, but as far as the specifics that it's possible that Mr. Jackson did something, I believe that was a new issue introduced by the state, and for those reasons, I believe that it's
Yeah, it was.
defendant to call Mr. Lyon, so we will allow Mr.
Be
Lyon to
be
testify,
snarky,
and then I understand
Jordan. Say
Mr. Johnson,
something.
that you anticipate that is your last witness, is that correct?
Yes, Your Honor.
All right, let's make a record on that then as well. My understanding, based on informal conversations, is that Mr. Jackson will not be testifying. Is that correct?
That is my understanding, Your Honor.
All right. So, and if Mr. Johnson, I'm going to turn it over to you. Have you had a chance to discuss this with Mr. Jackson?
Yes, Your Honor.
Any record you want to make about your discussions with Mr. Jackson and his testimony?
Did the court want me to conduct the colloquy, or?
I'll do that. I just want to know if there's any record you wish to make.
No, Your Honor.
All right. If you want to pass that microphone down perhaps to Mr. Jackson.
Now they're going to ask him a bunch of questions. Have you made this decision willingly? Have you been forced to make this
Good morning, Mr.
decision?
Jackson. Good morning. So, Mr. Jackson, you understand, sir, that you have a right to testify. Is that correct?
Correct.
All right. And there's a lot of things during the course of a trial that are strategic choices that lawyers get to make on behalf of their clients. This is not one of those choices. So you understand that whether or not you testify is solely your decision, not your lawyer's decision, not my decision, not anybody's decision except yours. Do you understand that?
Correct.
All right. I'm sorry. Is that a yes?
Yes.
All right. Have you had enough time to talk about your decision to testify or not with Mr. Johnson, Ms. Garner, and/or Ms. Foley?
Yes.
All right. And are you satisfied with the advice that they've given you in connection with your decision to testify or not testify?
Yes.
Have you had an opportunity to ask any questions you may have about your decision to testify?
Yes.
All right. And is it your decision then to not testify in this proceeding?
It is my decision not to testify.
All right. And do you believe that you've had, do you believe you have all the information you need from your lawyers to make an informed decision about whether or not to testify?
Yes.
Anybody pressured you in any way to not testify? Anybody threatened you in any way to not testify?
No.
Is your decision not to testify in these proceedings, is that your own voluntary decision?
Yes.
All right. Mr. Johnson, any further record you believe needs to be made on the matter? Ms. Slaughter or Ms. Shear, any further record either of you believes needs to be made in this matter?
I think the colloquy conducted by the court was sufficient, Your Honor.
All right. So then just so we're clear, we also talked about, I think on the record, my understanding, Mr. Johnston, you may wish to make another motion at the conclusion of your case before rebuttal, but we're not going to, we'll do that rather than sending the jury out. We've all agreed that you can do that once we've let the jury go, and we'll treat it as if it had been made at the conclusion of the defendant's case. Is that your understanding?
Yes, Your Honor.
Is that correct on the state's end?
It is correct, Your Honor.
All right. So what we're going to do then is we're going to bring the jury back in about 2
Well,
minutes.
why?
It's at
Because
11
he's
o'clock.
already going to deny it, and he's going to
We'll,
say, nope,
we need
never
to
mind.
come
There's
up with
enough for the
exhibits.
jury to decide.
Ms. Slaughter, I guess, why don't you go ahead and make your record with respect
But
to
for the record, you got to make it.
defendant's exhibits P1 through, what's the last number?
148, Your Honor.
P1 through 148. So Ms. Slaughter?
Your Honor, the state very recently was provided a binder that included several family photographs that were taken from the Jackson home.
Family
I did have the
photograph.
opportunity to review those photographs. I do believe that there are some contained within that binder that are relevant, but the vast majority of them I do not believe are relevant to any issue before this court, and am objecting to them. I did provide the court with a list of the ones I am not putting up any resistance to. The rest of them, Your Honor, just to give you an example of one, the day the defendant was born, I think that there is zero relevance to this trial for the majority of the photographs. I think that their only use or purpose would be to inflame the passions of the jury, to attempt to gain sympathy for the defendant. The vast number of photographs that were on the walls in the Jackson home is in no way issue in this case. The mom putting up old family photos on the walls is irrelevant, and so I am objecting. I don't have the specific numbers of the ones I'm objecting to. I did provide the court a list of the exhibits that I'm not objecting to.
And just to be clear, your objection is relevance, and I think you cited some other things too.
There was one, I'm going to call it a document contained within that binder that was provided to me that appeared to be some sort of a scouting certificate. I don't know exactly what it was right now, Your Honor, but I do believe that that was hearsay and also irrelevant. But relevance is my leading objection. I do think the photos for inflaming the passions of the jury. And so for all reasons I've seen, I am objecting to the on my list.
Don't show the picture.
Just to be clear for the record.
Don't show the
defendant's
pictures.
exhibits
That's
P1
going to
through
show
148.
all the fun
list
family
of the ones
times.
that I believe the state indicated they are not objecting to are P1, P6 through P9. And I'm just going to skip the P and reference the letter designation 24, 32, 57,
Why? You don't want to say
67,
PD no more?
75 through 77, 81, 84, 90, 92, 100, 101, 103, 111, 112, and 148. Is that correct, Ms. Slaughter?
That is a correct recitation of my list, Judge.
And to be clear again, those are the ones the state has no objection to admission.
Correct.
All right. Mr. Johnson?
Thank you, Your Honor. I don't have the exact word that Mr. Scheer used in opening statement. Maybe he does, but he definitely intimated to this jury in opening statement that this family had problems. I can't remember again the term that he used, but there was something dark or something sinister or something unknown, that some family secret or something. I don't want to misquote him, but I remember him saying that in opening statement. Relevance is a very low bar, Your Honor. It's just evidence tending to prove that something was true, tending to prove the proposition of something. These photographs, and there were photographs all over this family home, and the state is agreeing to stipulate that these were pictures taken from the family home and that they accurately depict the family, the people involved, the mother, the father, the sister, and of course, Mr. Jackson. And we believe that we have an obligation to respond to the claims made in opening statement that this family has some kind of problem. Obviously, by these pictures, it shows that this family was a family that was very proud of itself as a family and displayed pictures accordingly. It shows that the family interacted, Your Honor. It showed that they did things together. It showed that they were a normal family in that respect. Whether or not there were problems between the defendant and his sister, disagreements that they might have had or whatever, is normal family stuff. And if the state is trying to suggest, I think, that there were these forces behind the scenes in this family, and so we should be able to meet that with the showing that they have all these pictures of themselves together. And so for that reason, Your Honor, we believe they are relevant. I would also note that we would be willing to take out the scouting certificate, even though I think that that's in the record, that he did achieve that, and there was a witness who testified to that. But I don't have any problem taking that one out. And also, even though it's 1 through 148, there were a few duplicates that we did remove. If you want me to list those, because those won't actually be numbers in the list. But even though it's 1 through 148, we did remove 11 of them.
Okay. None of those 11 were ones agreed to by Ms. Slaughter.
No, because they're not in there now. So
Okay. All right, Ms. Slaughter, back to you. Any further record you wanted to make?
Again, Your Honor, even after having listened to what Mr. Johnston just argued, I still don't see how proving that the defendant was a cute baby when he was born is relevant to any fact and issue in this case. The photographs are cumbersome. 149 photographs or 48 photographs are not necessary to prove what he is attempting to prove. I think that the state is being more than generous with the 22 that we're agreeing to. And for all of the other reasons stated, I'm standing on those reasons for this objection as well, Your Honor.
All right. Well, I mean, in some respects, this is a little bit duplicative, not entirely, but a little bit duplicative to the objection and argument made with respect to the autopsy photos. So, I mean, essentially for the same reasons, I do believe there's some relevance. But, you know, the state whittled down the autopsy photos when they selected the ones to present. You know, I believe 148 pictures is excessive. I will say there's also already video evidence of all the pictures in the house in the record as a result of the body camera video footage. You know, I think, you know, more than a few has limited additional relevance, adds a very little bit. And I think Ms. Slaughter alluded to it, that it's just too much. And I think it's kind of confusing, a waste of time, and adds little probative value to the record. So go
May
ahead.
I add something, Your Honor?
Go ahead.
That I find it incredible that before you make this ruling, that you are going to let the state select what photos we can use. If you are going to limit the number, then we should have some input into what those pictures are.
Well, I mean,
If you want to give me a number, Your Honor, if you want to give me a number of what you feel is the appropriate number, then I should be able to look at those photos and pick the ones that we want to use.
Well, then go ahead and do that. I mean, these pictures have just shown up today. I mean, neither
No.
hold on. I mean, Ms. Slaughter had said she hadn't seen them before today.
No, we gave her a disc.
If she didn't know which ones you were planning on offering.
We gave her this disc that are these exact same photos, Your Honor. She's had that disc for a couple of weeks, I would say, and we've had, or probably longer than that, and we can find that out.
Okay.
Well, this is not a surprise. The actual exhibit preparation it's in a binder. It's not cumbersome at all.
Okay, I get it. Ms. Slaughter, did you want to add something?
I do just want to clear that up, Your Honor. All of the photos that Mr. Johnston did present me, I have seen at the same time that he filed them online. The problem was that they were filed with absolutely no numbering system. And so we have gone back and forth on how to identify the photographs that the state has objected to, but they were provided to me timely, just not labeled.
All right, then that's my misunderstanding. I apologize.
We filed them on January 3rd, Your Honor.
I
on
apologize.
meeting
So
minutes.
I guess I'm going to say to both of you,
Okay.
it's frustrating that I'm being,
Oh,
being dumped on my lap at the last minute, right? I mean, if the state had an objection, and again, I understand this could have been a numbering issue. Again,
I launched that objection, and I've launched it multiple times and asked the defense to provide me the exhibit number so that I could make a formal record. So I have very clearly for a very long time said I have objecting to them putting in those exhibits. And
not to me. I don't recall that. So, but regardless, I do think 148 is excessive. So you guys want to whittle it down to, 20 to 25 pictures? That's reasonable. I also do agree with Ms. Slaughter that, why is a baby picture relevant? I don't know, but I think 148 is excessive, more than necessary to make your point. So, I would ask that you whittle it down to some, again, approximately 25 pictures.
Well, are we going to do that before? I mean, I have to offer this exhibit
I
in front of the
understand.
jury. So I'm not going to just,
pick your
Like I
favorite
said,
25
I'm
and
frustrated as
move.
everybody else.
on.
This is, this was this is the first time that we've dealt with this, at least that I've dealt with this. So you guys may have had discussions about this, but certainly I don't recall addressing an issue.
148 pictures, family
So,
photos.
What do you need? What do you
You're
need?
really only trying to do that to show a happy family. Like, that that's what you're trying to do. And sway the jury.
You may.
Obviously, we're going to have an argument.
I understand, but, you know, I mean, again, I think 148 is too much.
Yeah, I think 25 is too little, Your Honor. It's a totally arbitrary number on both ends. So I think we have, based on what the state said in opening statement, we can show what we're up to.
I mean, my notes reflect that what Mr. Scheer said is that the defendant was going to make it seem like, where is it? Oh, here. He said it's not a perfect family as claimed by the defendant, something along those lines. So, maybe. So,
Do you have it?
I guess my question is obviously we're going to have an argument if the 25 aren't excluded. I don't know how many years this other.
yep. I mean, if you guys got different 25 or 30, again, 148 is,
I don't have a problem turning down Your Honor's offer.
right?
I don't have a problem taking the date commission's offer. But I do have a problem with the state dictating what our.
I never said that that's the ones, so. I mean, if you guys have a good case to be made for a couple more, I'm willing to listen, but I mean, again, 148, and I mean, I looked through them, there's multiples of the same event, the same thing.
He is being a little bitch. Like, knock it the fuck off. You're throwing a little temper tantrum. Oh, now you're going to eyeball the judge? Get to picking.
All right, so here's what I suggest we do. Why don't we get Mr. Long to testify, let the jurors go for lunch, because I mean, it's going to be, by the time he's done, and then, you know, they can come back at 1:30, and we can take up rebuttal, and before rebuttal, we can address the exhibits and offer and admit those that we've made a record on. All right, does that work for the state? Mr. Johnson? All right, let's get the jury in and take up Mr. Lyons then.
Dear Lord. He just sat there and threw a whole fit. Over some pictures. You don't need that many. First of all, the jury is not going to look at 148 photos of this family. They're going to look at 25 and they're going to be like, okay, looks like a happy family. But something obviously went wrong.
I'll wait till Tyler gets back in. I was mainly talking to myself. Yeah, but I don't think we're going to be able. No, yeah, we're ready.
Are we ready? Are we ready? Mr. Lyons, come on. Are you ready?
All right, go ahead and have a seat. All right. Thanks for your patience, ladies and gentlemen, as we work through a couple things. At this point, I believe we have an additional witness for on behalf of the defendant, Mr. Johnson.
Yes, Your Honor. The defense calls Chris Lyon.
Mr. Lyon, have you come on up and sit over here to my far left, sir? All right, Mr. Lyon, that microphone is on, so you can adjust it however you'd like. And Mr. Lyon, I'm going to go ahead and swear you in. Please raise your right hand. Mr. Lyon, do you swear or affirm, sir, that the testimony you'll be giving this morning will be the truth?
I do.
All right. And then just for the record, can you please give us your first and last name and spell them both?
Christopher Lyon, K-R-I-S-T-O-F-E-R-L-Y-O-N.
Mr. Johnson?
Thank you, Your Honor. Good morning, Mr. Lyon.
Morning.
Could you explain to the jury how you are employed?
I work for the Office of the State Public Defender in Iowa City, and I'm an investigator, and I also work as a digital forensics specialist.
How long have you been working for the Public Defender's Office in Iowa City?
Let's see, since 2018, I believe.
How long have you worked in the public defender system?
Just a year before that, I started.
Okay. And what kind of a job did you hold before that?
I was in law enforcement, a police officer. I worked for West Liberty Police Department.
Okay. And can you tell us a little bit about your educational background?
Sure. So I have a BA from Lewis and Clark College in Portland, Oregon. Attended the Iowa Law Enforcement Academy, various law enforcement training. And then with the Public Defender's Office, I've had the chance to take a fair amount of digital forensics, computer-related trainings and certifications.
And are some of that training called Detailed Records Best Practices for Legal Requests in January of 2020?
Yes.
And that was Hawk Analytics?
Yeah, I've taken some classes
Love
from
it.
Hawk Analytics. Yes.
And what is Hawk Analytics?
They're a private company that they do a lot of work, and they have a online platform related to like cell phone record mapping, like from cell phone companies, tower records, that kind of thing.
And carrier breakdowns, AT&T returns? Again, that's Hawk Analytics from August of 2020?
Yes. Yeah, same kind of thing. Understanding records from cell phone carriers.
And would that also be, I see you have Sprint on there as well?
Yes.
T-Mobile, right?
Yes.
And Verizon?
Yes.
And what is this beyond the map CDR analysis that was September of 2020?
So CDR analysis, it's just called detailed records. It's an older style of records kept by cell phone companies, just how to look at them, analyze, understand the data.
Are you also a Celebrite certified operator?
Yeah, I have Celebrite, so it's a proprietary company that makes software for downloading phones. I've taken a few classes and certifications with them.
So you are a certified Celebrite operator, correct?
Yes.
And you've also been trained in the Celebrite certified physical analyst?
Yeah, Physical Analyzer. It's another software program from Celebrite.
So I worded that poorly. You are a Celebrite certified physical analyst, right?
Yeah, sure. I think that's what they call it. They have all these acronyms. I think it's CCPA.
And Celebrite Analytics Desktop, you were trained in that in August of 2020, is that right?
Yes.
And Celebrite Mobile Forensics Fundamentals,
Yes.
also August of 2020, is that right?
Yes.
Did
Sure.
all of this training enable you to examine data from a Celebrite download?
Yes.
And can you explain to the ladies and gentlemen of the jury exactly what Celebrite is and what it does?
So there are a few companies that make software programs for downloading as much data as they can from a cell phone, especially in the law enforcement or courtroom context. It's useful to have information from a cell phone. Celebrite is one of those companies. It's simple from the outside. I mean, it's using exploits, basically bugs in the computer hardware in the phone or software that these companies have discovered that Apple or Android, that the makers of the phones, haven't been able to patch, repair, that allows the companies to bypass the security of the phone, get into them, and then download as much information as they can from the phone.
Or what kind of data can you get from a Celebrite download?
So I mean, it varies a lot by the age of the phone. Usually the newer the phone, the fewer exploits, or at least they haven't been discovered yet. But your average, they call it a phone dump, dumping the information from the phone, can include location information, text messages, social media information, call logs. I mean, there's just a massive amount of information on the phone that you can look at.
And would you be able to look at one of those Celebrite downloads and interpret the data that was on it?
Yes, yeah. That's the basics of the training are using the Celebrite programs to look through the data that was extracted from phones.
Yesterday, were you asked to look at the Celebrite downloads for the phones belonging to Jan Jackson, Melissa Jackson, and Alexander Jackson?
Yes, yeah.
And who asked you to do that?
You did, sir.
And were you asked to look specifically for the Ring app and anywhere it showed up on any of those phones?
Yes,
And did you do that?
I did.
Were you able to look at with respect to Jan Jackson, who would have been the father's phone, I think is the way it was referred to in the Celebrite data, were you able to see whether or not the Ring app had been installed on the father's phone?
Yes, the Ring app was installed.
Okay, and were you able to tell when was the last time the Ring app would have been operated or looked at or used in any way on the father's phone?
Yes, I looked at something called the application usage log. In Celebrite, you can, the iPhone in this case recorded the last time and for how long the specific applications were used. So the last time the Ring app was used on the dad's phone is how I had it referred to in the data, was June 13th of 2021. It was for less than a minute. It was active.
Did that correspond to any other event on that phone like a minute earlier?
Yeah, so I was looking at, so Celebrite, someone makes the software and they tell the program how to interpret the data from the phone. It can only interpret what it knows how to interpret. So common applications like your Facebook app, Instagram, Celebrite will know how to decode it because their programmers have told them, okay, take this data from the phone. These are messages, these are images, and then kind of display it in the Celebrite software. Not every application can be interpreted that way just because Celebrite hasn't written their software to interpret every application. So sometimes you have to look at sort of we call it the raw data, more of the files on the phone themselves, rather than Celebrite just kind of nicely handing it to you to look at. So in this case, I looked at some of the database files, which are what applications use to store data associated with them. So I just looked at the database associated with the Ring app. And on the 13th of June 2021 for the dad's phone, there were some screenshots, screen captures of images from some Ring surveillance video cameras. And it was a minute, maybe a little bit over a minute before the app would have been used for the last time.
So it would have been consistent with somebody getting one of those notifications, for example, that there had been motion or the camera had been activated, and then somebody looking at that video.
Right. I can't tell you specifically why those shots were taken. You know, my guess would be that it would be maybe motion activity recorded the images for the screenshot, gave a notification, and then the user manually opened the app. That would be my guess, but I can't tell you why they were taken. They could have been taken manually, various reasons.
But however, they had the camera set up. Is that right?
Can you say that again?
However, they had the camera set up.
Right.
But it would be consistent with getting a notification from Ring and then looking at that notification, would it not?
It would make sense to me. It's logical to me that if an image is taken and a minute later, we know the application is opened by the user, that, yeah, probably some notification was given.
And I know you don't have it memorized the exact time that these events were occurred, but do you remember, were they in the morning or the afternoon?
On the dad's phone, it was the evening. I think it was 6 o'clock sometime in the evening.
With respect to Melissa Jackson's phone, which would be the mother's phone, did you have an opportunity to look and see when the Ring app, first of all, did the Ring app appear on the mom's phone as well?
Yes, I did.
And could you tell by looking at that Celebrite download, when was the last time that Ring app would have been used by the mother?
I believe it was June 12th, 2021, sometime in the morning, somewhere 8 a.m. sometime.
Well, you say, I believe. I know you got the notes written down in your pocket.
Yeah, the exact time I have written down, but yes.
Okay. I just want to make sure we're clear that you know the exact times of these. And you can take that out of your pocket if you want.
Right. If you want the exact times, I have them written down.
Yeah.
It was 8:53, 24 seconds in the morning on the 12th.
And then while you got that out there, can you tell what the time was on when the dad accessed the phone, the Ring app?
6:20, 42 p.m.
On the 13th of June.
On the 13th.
Was there do you recall any corresponding photograph with that?
No, I don't remember if I didn't look through the database on that phone or if I couldn't find it. But no, I don't remember a photo.
Then with respect to Alexander Jackson's phone, which would have been brother's phone on the Celebrite download, did you see any evidence at all that the Ring app had ever been installed on his phone?
No.
No what?
No, I did not see evidence that the Ring app was installed.
Ever?
So I looked at the period of
we kind of narrowed it down to save time. So we looked at June, I believe we looked like June 11th to June 16th, 2021. And in that time period, I didn't see any evidence of anything to do with Ring. So I did a search for the common file names associated with applications, and no results were returned.
What do you mean by common files associated with the Ring app?
So just like if you on your computer, if you went into program files, you probably wouldn't have a reason to do that, but things aren't named like they are on your home screen of your phone. You know, on your home screen, you might click on Facebook, but in the background that you can't see, things are named like com, period, Facebook, with a lot of more information after it. So I did several searches for those types of file names to see if there's anything associated with a Ring application.
And you can answer this if you know, but in your experience, is the Ring app typically password protected?
Can you clarify more? Do you mean, like, I believe there's a username to log in generally to access it, but I don't know that you would need to do that once you have initially set it up.
But I mean,
Does that answer your question?
Yes, but the person initially set it up would most likely have a password they'd have to enter to initially set it up.
To initially set it, yes, I believe so.
And if someone had recently deleted the Ring app, would you have expected to find some evidence of that on the phone?
Yes. It's kind of a hard question to answer because it's like the absence of evidence is hard to find in digital forensics. There are different types of downloads, different types of extractions. Generally speaking, if something is recently deleted, you would see some evidence of it, some traces of it, some locations in like the application logs that mention it.
And would you expect, even if it had been deleted, that you would have been able to find where it had been installed?
Yeah, some things like that I would have to specifically test to answer. My assumption would be that it would still show up in installation logs. To give you a definitive answer, I would want to test it.
And how would you go about testing it to get a definitive answer?
So it's kind of a nice thing about digital forensics is that you could go buy the same brand of phone, set up the same variables as you have in whatever your question is. So install the same applications, log into the same sites, kind of set it up in the same way. And then if my question is, will something show up in Celebrite if I delete it? I could just delete it, download the phone, and see if that item still shows up. So testing is usually the best way to answer those questions.
But in general, you would expect to see some evidence that the Ring app had been on there.
Generally speaking, if it was recently deleted, yes.
And did you see any evidence of that in Alexander Jackson's phone?
No.
And did you see any apps or programs commonly associated with the Ring app on Alexander Jackson's phone?
I'm not sure what I didn't see files associated with it. I'm not sure what another application associated with Ring would be.
I misspoke. But did you see, not apps, but did you see other files commonly associated with Ring that appeared on Alexander Jackson's phone?
No.
Would that also be consistent with the fact that the app had never been installed on Mr. Jackson's phone?
Yes.
Fantastic.
Did you also have opportunity to look at any Ring data that was provided to the Cedar Rapids Police Department?
Yes.
And these were some video files?
Yeah, I didn't look at the video files themselves, but when the police serve a search warrant to a technology company like Ring, they usually get a return with data files. So I did look at data files in this case.
And did the data files that you looked at indicate that there had been done anything to the cameras, or did it not indicate anything at all?
There were no logs or anything that showed either way, nothing to show any kind of activity. It was just video files.
Thank you. I don't have any further questions.
Cross-examination, Ms. Slaughter?
Thank you, Your Honor. Mr. Lyon, you said that you did a search for common files associated with the Ring app, correct?
Yes.
And by doing a search, you just mean that you went in and did like a keyword search to see if those files would pop up, right?
Right, in advanced, yeah, they call it advanced search and keyword search.
Where did you get the file names, the list of file names that you were keyword searching?
I mean, just experience that like the com.ring is usually what they're called. And then on the other phones, the other two phones that I looked at, I could see what the file names were used, for that application.
And so you took the file names from the other two phones and keyword searched it for Alexander Jackson's phone.
I mean, sort of. It's not like there's any fancy secret word here. I mean, com.ring, ring is the name of the company, and that was what it was on the other phones. And then, sorry.
No, go ahead. I apologize. I didn't mean to cut you off.
And then the com prefix is pretty common. So,
And you said that your title is a digital forensic specialist. Is that correct?
yeah.
But you're not a forensic analyst, right?
That's not my title. I don't know how to answer that.
Well, can you tell us the difference between a forensic analyst and a digital specialist, digital forensic specialist?
Not really. I mean, I picked my title. I kind of started I did start the digital forensics program with the public defender's office in Iowa. So I don't know. I made my title. I could have made it analyst.
Forensic analyst is an actual thing, right? It's not something that you can just pick.
Forensic, I don't know. It depends on what certifications you have.
Bitch, I could have picked whatever the fuck I wanted to be. I could have said I was
Certain
president.
organizations list.
Hey,
You have
stop.
this title now because you've been certified by this organization. But
You said that you confirm whether or not this
Hold on.
application was ever on the phone, that you'd want to test it by buying a phone and setting up the same variables on the phone that you were analyzing in the new phone that you would purchase, correct?
yes,
And wouldn't it be true that those same variables would be the same type of phone, right?
yes, same model of phone.
The same app,
Yes,
but the operating system or the degree of updates that have happened on the app would also be important, right?
yes,
So if you set up the Ring doorbell app, you'd want to make sure that you had the same app from 2.5 years ago, right?
to test it.
Yeah.
I mean, that would be ideal. Yes,
And same for this iPhone's operating system, right? In order for it to be the same variable, it would need to be the exact same operating system that was running then.
yeah, ideally, yes.
And you can't go back and download old operating systems on iPhones, correct?
I don't know. You might be able to with the developer account with Apple. I don't know the answer to that.
Now, Mr. Lyon, isn't it true that you cannot say definitively whether or not this app was ever on the phone?
Which
The Ring app.
could you tell me which phone?
Well, we know it's on the dad and the mom's phone,
Okay,
correct?
I just want to make sure we were talking about the same thing.
Okay, so we're talking about the son's phone. I think that's how you named it, or how the file was named when you received it, correct?
Okay, yes,
And if the son's phone associates with Alexander Jackson's phone, we're talking about the same phone.
Okay.
Okay.
Yes.
Isn't it true that you
This
can't
is
definitively
what I
say
do.
whether or not the app was ever there or wasn't ever there?
that is correct. Yeah,
All you can say without a doubt is that the app was not on the phone at the time that Celebrite downloaded or did the data dump that you referred to, correct?
I think that it's fair to go a little further to say that I also didn't see evidence of a deleted app. Can I say with 100% certainty that the app was?
Never there?
Make sure I get the language right. Can I say with 100% certainty that I know there wasn't an app that was never deleted? No, I can't tell you that.
And other than searching for those files that you would have expected to see or that you say you would generally see, there was nothing additional that you did to validate the information that you found in that Celebrite data, correct?
Could you just clarify validate for me?
As a forensic specialist, there are steps to take to validate information that you received, correct?
If you're talking about like verifying image hashes, I do that as a standard practice. So I did that. I didn't do any like external testing, or like if that's the question.
But she just looked at it and said, no, it wasn't on
Mr.
this
Lyon,
phone.
Mr. Johnston asked you about your experience prior to becoming this self-proclaimed digital forensic specialist. Do you recall that line of questioning?
Objection to the term self-proclaimed, Your Honor.
He said he named himself that, Your Honor.
Objection, well, go ahead and answer.
Can you give me more specifics? Like talk about being in law enforcement?
Yes.
Or okay.
And you said that you were in law enforcement, correct?
Yes.
Self-proclaimed.
And
You
were
better
a
bitch.
police officer for West Liberty Police Department?
Yes.
When you worked for West Liberty Police Department,
petty
how long
as
did you work there?
It was part-time, few months. I was at
What year?
university. Sorry,
What year?
2000s. It was right before I started the public defender's office. So 2007, 17.
I'm sorry, 2017?
Is it? 2000. Might have been 2018. Yeah, I think 2018 sometime. Yeah.
Does that conclude your law enforcement experience prior to working for the public defender's office?
No, I was chief of police at University Heights Police Department.
But you didn't name that position originally, correct?
No, I didn't.
And is that because there was a vote of no confidence on you while you worked in that capacity?
No, it was just the most recent experience.
It
I'm happy
wasn't
to-
the most recent experience, though, correct? You were fired from the University Heights Police Department in 2018 after a vote of no confidence, correct?
I feel like there's two questions there. That is true. I worked at West Liberty after University Heights Police Department. So West Liberty was the most recent law enforcement experience.
And you said you worked in West Liberty in 2017,
I think I misspoke. I think it was 2018. It was after University Heights.
and you were terminated from University Heights in 2018.
I think so, 2017, 2018. I don't remember the exact date.
I don't have any further questions, Your Honor.
Redirect, Mr. Johnson.
Thank you, Your Honor. Mr. Lyon, does that have anything to do with your ability to analyze Celebrite data?
No.
And did you analyze the Celebrite data that was provided from the Cedar Rapids Police Department in this case?
Yes.
And so, in terms of whether the data was valid or not, that data came from the Cedar Rapids Police Department, did it not?
Yes.
When Ms. Slaughter asked you about the test that could determine whether or not the Ring app had been on there definitively, I understand it's your opinion that the app was not on that phone ever, on Mr. Jackson's phone, but to definitively say it, you could do the test like you proposed doing, right?
I think that testing is the best way to give yourself the information about whether or not Celebrite would show a deleted app. If it was deleted long ago, it might never show up. But testing is kind of the best way to determine if something like that would show up in the Celebrite extraction.
So if it had been recently deleted, you would have expected it to see it in the Celebrite download. Is that true?
Yes, generally, yeah.
And if you wanted to make it definitive and do the test, then the best time to have done that test would have been shortly after the download. Would that be true?
Right. If you're concerned about the software updates and versions, you would do it at the time so that you could mirror it as closely as possible.
So when Ms. Slaughter was asking you about going back 2 years to do this, if the Cedar Rapids Police Department had done it 2 years ago, then that wouldn't have been a problem, right?
Assuming that the phone had the most current version of the software at the time, yes.
So the best time to do the test would have been right after you did the download, right?
Yes.
Then you wouldn't have to worry about how many updates the Ring app had, right?
Yes.
Or the updates on the phone.
Correct.
Right. Like these lawyers are just like petty. I don't think I've ever really seen like pettiness.
That's all the questions I have. Thanks.
Recross, Ms. Slaughter.
No, Your Honor.
All right.
Thank
Mr. Slaughter,
God.
please step down and you are free to go. So, ladies and gentlemen, you may just be wondering where we're at. I think I can tell you. So, we are going to be done for the morning at this point. We're going to have one more witness, I believe, from the state. I don't believe the defendant has any more witnesses. I think there may be a few more exhibits that will be offered. We'll deal with that right after lunch. Then we'll have a witness from the state. I think at that point, we will let you go for the day. And then, as I indicated, I think we talked about Friday. One of the possibilities was we'd be doing closing arguments Tuesday morning. I think that's where we're going to be at because there's going to be a couple of things that we need to take up and address once all the evidence has been submitted. We'll work on finalizing jury instructions, take up a couple other matters. And then again, just for your scheduling purposes, again, you'll have your normal lunch break now, asked to be back at 1:15. I guess you'll be here no longer than an hour after lunch, plus or minus a little bit. And then let you go early today and ask to be back here ready to go by 9 o'clock tomorrow when we'll give you jury instructions and closing arguments. All right. So with that, I'll remind you of the admonition that I've given you and ask you to be back here ready to go by 1:15.
We're 3 hours
Go ahead,
in,
see.
but we've only done a
Right, just for our
hour and
purposes
20
then, here's what I'm gonna suggest we do.
court.
Again, this exhibit issue, again, was it's a new issue to me. I'm gonna go back, think about it, do a little research. I don't know if you guys have pared down your list. Why don't you show it to Ms. Slaughter and we can see where we're at, and then maybe we'll come back here at, say, 1:45 and make a record on the exhibits. Then let me ask you, anything else we need to take up on the record at this point, Mr. Johnson? Ms. Slaughter, Mr. Shear, anything on the record at this point? All right. There had been an objection or an issue answered that voluntary manslaughter. Thinking about this, there's two types of voluntary manslaughter. There's the aggravated misdemeanor and the felony. The felony involves a public offense of some kind. No evidence of any sort of public offense. And so also no evidence of any sort of act on behalf of the defendant. In this case, it talks about not submitting either. I'm just not sure that either alternative of involuntary manslaughter is supported by the evidence. And so I just want to have informal. We want to get people's input on that before I make a final decision on my end. Because I heard nothing suggesting for a public offense by anybody, not much less public offense by a defendant. And the evidence doesn't submit any sort of reckless act by the defendant either. So. Okay, and you want to?
We are after lunch. Oh my God. Okay, well, Jiminy Christmas.
So where are we at? On your.
Oh,
okay, and you want to?
how many pictures? I know he said more than 25.
May I make a proposal as we go through these, since they're not electronic anywhere? Other than the number, I don't really have any context to what they are, so I need to show them to me so I can make my argument about them, I guess, is my request, since I can't hold them on EMS.
Let me ask you, I guess before you have objections, individualized objections to these?
I don't know if they're individualized, Your Honor. I don't know if they're individualized.
You have individualized objections.
No. Okay. Right. So I guess that's what I'm at.
Yeah, relevance and the prejudice being greater than the appropriate value of these photos in the value. Yes.
All right. Someone will want this. Are you guys ready? Okay. All right. We are now on the record. We have counsel and Mr. Jackson present. We are outside the presence of the jury. We are here to address the photographs that Mr. Jackson wants to offer in evidence, and we addressed this on the record earlier. I think there's a generalized agreement that some of the photos should be admitted, and there's a general agreement, well, a specific agreement that state's not objecting to any of these based on foundation, et cetera. So before lunch, I think the state had P1 through P148, but I understand of those, 11 had already been removed, so there were only whatever 148 minus 11 is, 137, I believe, roughly. But over the lunch hour, I understand the defendant has further redacted or omitted some of the exhibits and now only wishes to offer approximately, I can't remember, 50 some, but go ahead, Mr. Johnson.
51, Your Honor.
All right, and do you have the numbers of the 51 you want to offer?
I do.
For
All right,
goodness sake.
I'm going to ask that you go slowly for both me and Kathy.
So some of these are numbers between numbers. So do you want me to list them individually, or do you want me to, if I say 6 through 10, is that okay?
That's fine, and these are all part of a defendant's exhibit P, correct?
P.
All right, so I think knowing that you could admit the P, so just give us
Okay.
the numbers.
1, 6 through 10, 13 through 15, 24, 25, 28 through 30, 47, 48, 32, sorry about that, 57, 67, 75 through 78, 80, 81, 84, 86, 87, 88, 89, 90 through 92, 94 through 103, 105, 111, 112, 116 through 119, 137, and 148. We believe, Your Honor, that adds up to 51.
I'm sorry, I didn't catch that last part, Mr. Johnson.
I said we believe that adds up to 51.
All right. And just to be clear, at this point, this is all of defendant's exhibit P that the defendant wishes to offer.
In light of what the court has said, we are willing to compromise and offer this and give up our objection to the other photos that we originally planned to offer.
All right.
Good
Over to you,
job.
Sorry. Over to you, Ms. Slaughter.
Thank you, Your Honor.
Didn't mean to get you in mid-bite.
That's okay. I apologize. I am making the same objection that I made prior to us taking our break. I did have a brief opportunity to review the additional photos chosen that get us from the 22 proposed by the state to the 51. They're old photos, Your Honor. It looks like they removed the infant stage, but we are still at the very adolescent stage, prepubescent, no facial hair, 10 plus years ago in a lot of these. There's photographs of a dog that they don't own anymore. There's photographs of family vacations that were well over 10 years prior to this happening. If there is any relevance in these additional photos picked out by the defendant, the prejudicial effect of inflaming the passions of the jury and trying to suggest that because 10 plus years ago they had a great family vacation so the defendant couldn't have killed him it's prejudicial. There's limited, if any, probative value to these additional photographs. I think that the state has been very generous in the 22 that we're allowing in without any foundational objections, and that they're more recent in time. But how many photographs do we need of the defendant playing his flute? How many photographs do we need of the defendant in his Eagle Scout or Boy Scout outfits? They're duplicative and old. And for all of those reasons, we don't think that they're relevant, and we do think that they're, if relevant to any extent, that the prejudicial effect outweighs any probative value that these additional 20-some photographs is going to offer.
They're not going to look at all 51 anyway.
Johnson.
Doesn't fucking matter.
Is there anything further to say?
I did, Your Honor. First of all, that's what we went through and did, is try to remove like photos of, depicting similar things. What we did with the older ones, they're not little kids, they're not babies, they're young, they're younger, but they're family photos. They're pictures of them as a family, which is what we're trying to show here, is that these are family photos. So we endeavored to take out all the little kid baby photos and also anything that was already represented by another photo. Like, so we don't have multiple photos.
They probably
of them in
don't have
Eagle
any
Scout
recent
uniform.
ones
Multiple
because
photos of them
nobody
playing
puts up
flute.
pictures anymore.
So we endeavored to do what the court asked by dropping this down to 51, and it's not inflaming the passions of the
tell you
jury,
last
and the state doesn't get to pick our
printed
exhibit
out
for
a
us.
picture.
They're not being generous when they say they're only 22. They shouldn't even have a say in this, except to make their objection as to relevance or whatever else. They don't get to pick our exhibits for us. And the idea that they're being generous just blows my mind. So I'm offering this as to respect the court's view of this. I'm giving up an objection to something that I wanted to put in a larger number in. We have endeavored to pare this down, and that's what we've done.
Ms. Slaughter, anything further?
I think that it's just ironic that Mr. Johnston can make those arguments when he literally objected to autopsy photos. Where is the probative value in these? In Christmas photos from 2013 and 2014, I just don't see it. And before the court makes a determination, I'm hoping that you will be provided the photos finally so that you can flip through them and see exactly what photos we're talking about. Because I think that when the court looks at them, you're not going to find the probative value that Mr. Johnston hopes you find in them.
All right. Do you have is the binder full of the ones you want to admit at this point? All right. Can you bring that up to me, Ms. Garner? I mean, I looked at all of them previously, but obviously I can't place a number to an individual photo. All right. Got it.
And if you're gonna have a family photo besides a selfie, you don't print that shit out. All the photos on my wall are hella old. And all the photos in my photo albums are hella old because everything I have that's recent, I bet you, is on mom's phone. And if they wanted anything recent, they would have had to have access to mom's phone and the pictures in mom's phone. She's the one that would have had the most recent family photos. Not what was ever in photo albums and shit. That shit don't count. Oh. Trying to think. Like, what is the newest family photo that we have? It's probably this one. To be quite honest, this
Let me
one.
ask Mr. Johnson, there's a lot
Did
of
you
photos
see this one?
here. I should say several of the photos are just of your client individually.
My daughter is about to be
Uh,
9.
And how does that add?
My son is
I mean,
16.
again, I understand why you want them, but I mean, the family photos, I understand your argument, and I understand the state's position on the argument, but I mean, there are numerous photos in here that are just of your client. How does that add to the family picture?
They back up our testimony that we've had from people saying that he participated in flute, that he participated in Eagle Scouts. So it's support for those things that we have had testimony for.
She was probably 3 in this picture. It was like 6 years ago. Like she said, how many pictures you need of him playing his flute? He was a flute player. Good for him. Just come on.
I don't remember. It started with P1.
Stupid. Are we still just gonna be looking at their pictures? Dear God. Move along, move along. La-di-dee, la-di-da.
All right, I got P96 of the defendant and his dog, and then P97, it looks like with the defendant with his dog. I got 2 of those. Again, these aren't family, but any particular relevance to these 2?
Can I see him, Your Honor?
You may.
Well, the relevance would be, I think the state is trying to suggest there's some questioning witnesses that the defendant wasn't close to his dog or wouldn't sleep with his dog. The arguments they're trying to make is that he wouldn't be
fuck's
sleeping with
sake.
his dog on porch. And that suggestion has been raised in some of the questioning of the state. So that's why those are in there.
I don't recall. I mean, I recall that was a potential issue, but I don't recall that coming up at all during trial. Do you, Mr. Shearer or Mr. Slaughter?
I do recall asking one of the state's witnesses one of the defendant's witnesses, if he ever saw the defendant and his dog sleep on the porch.
Yep.
That's the extent of the questioning, and that's not the same dog either.
Can we?
Yep. And while we're at it, there's a couple more. These are P116 and 117. Okay.
We withdraw 97.
How do they know it's not the same dog? Are we done yet?
All right, so just to be clear, you've withdrawn P97.
Yes, Your Honor.
Oh,
Right. I've looked at the photos, and again, the state's conceded that some of them should be admitted. It's just really, where do you draw the line on relevance? At this point, are there any other objections other than as noted? All right, I'm going to admit P1, P6, P7, P8, P9, P10, P13, through P15, P24, P25, P28, P29, P30, P32, P47, P48, P57, P67, P75, P76, P77, P78, P80 through P81, P84, P86 through P92, P94. I see P95 is just a picture of the defendant much younger standing by himself. I see no potential relevance to that picture. P95, I'm not admitting. P97 was withdrawn. P117, again, is just the defendant and his dog. P116, P96. So I'm not admitting P95, P97, P95, P117, P117, P116, P98. These are all P99, P100, P101, P102. These are all defendant just by himself. There's already pictures of him in Cub Scouts.
nobody cares.
All those are out. P99, P100, P101, P102. Again, these are all, those that I just mentioned are all just the defendant standing by himself, either with a flute or Cub Scout uniform. There's plenty of pictures that have been admitted, that are being admitted, that show him as a Cub Scout or with his flute.
How many pictures do you need of him with his flute? Dear God, this should not be that goddamn difficult.
Same with P05, P11, P112, P18, and P119. Those are all, again, not family pictures. They're either of the defendant by himself or band or scouting. And again, there's already pictures that have been admitted showing those activities. Plus, the defendant really hasn't articulated relevance. His argument with relevance was that these pictures were relevant to the family situation, and those have nothing to do with that, at least on their face. So the ones that are admitted, do you want me to go through those again? Or does everybody have it?
No,
P6.
everybody has it. Leave it the fuck alone. Grumpy little man.
95, 97, 96, 98, 99, 100, 101, 102,
Bless you.
105, 111, 112, 117, sorry, 116 as well, and 119. I've taken them all out of the binder here. So it's just the ones in front, or starting here with P1. All right, anybody have any questions about where we're at this point? Yep. So I just give these to you, so we just have. Well, why are you going to scan these in? Yeah, I understand. Just so they're not going to show them to the jury now. What's your concern?
They're not, you fucking weirdo.
Well, I can give you an envelope later, but you'll also need to scan in those others that I pulled out and just give you separately so that they're available for the record. All right. Are we ready to bring in the jury? So then when we bring in the jury, Mr. Johnson will offer all of his exhibits. Well, we'll just consider those offered already. Anybody have any objection to that? The ones that I said I'm not admitting of the ones he wanted to offer, let's just consider those offered and I'm not admitting them. So he doesn't need to make another offer in front of the jury. Is that acceptable for everybody for record purposes? And then just offer the ones that are in there. The state can just say, other than the objection already made, no further objection, I'll admit them. And then we'll go on to the state's witness. I'm happy to do it. If you just bring me the binder, I'll just read out the ones that you're offering. And I'm happy to do it. Well, they'll go to the jury. You'll need to bring them back and scan them. So, all right. Are we ready to bring in the jury? Yep. Are they here, Terry? All right, let's bring them in. And who are you calling? Holtz. Holtz, H-O-L-S-T. All right, thanks. Good job. We already said that. Yeah, yep. We put that on the record.
Let's move it along. Let's move it along.
All right, ladies and gentlemen, go ahead and have a seat. Hope you had a good lunch. All right, so we have our jurors back. We have counsel, Mr. Jackson, back. At this point, I believe the defendant has some additional exhibits that he wishes to offer. I'm going to just go through those. I believe we have exhibit.
Okay.
These are all, start with the
Well,
letter
one.
P.
Mhm.
So P1, P6 through P10, P13 through P15, P24, and P25, P28 through, and including P30, P32, P47 and P48, P57, P67, P75 through 78, so 75 through 78, P80 and 81, P84, P86 through P80, actually all the way through P92, so P86 through P92, P94, P137, and P148. You wish to offer those at this time, Mr. Johnson? Other than as noted, any further objection, Ms. Slaughter?
No objection, aside from what has already been made a record of, Your Honor.
All right, then at this time, the exhibits that I just mentioned are all
He
admitted.
already said that. You had to repeat exactly what he
With
just
that,
fucking said.
Mr. Johnson, does the defendant have any further evidence?
No, Your Honor, the defense rests.
All right. Ms. Slaughter, does the state have any rebuttal?
Your Honor, the state would call Jeffrey Holst to the stand.
Good afternoon, Mr. Holst. Can I have you come on up here to the seat furthest to my left?
He's the one that is going to tell us everything we need to know. He's going to wrap it up and he's going to tell you exactly.
Go ahead and have a seat.
Okay, thanks.
And that microphone's on, so just you can adjust it however you'd like.
Sure.
All right, sir, I'm going to go ahead and swear you in. Mr. Holst, do you swear or affirm that the testimony you'll be giving today in this matter will be the truth?
Yes.
All right, you can put your hand down. And then just for the record, can you please give me your full name and spell both your first and last name for me?
Sure. My first name is Jeff, Jeff. My last name is spelled Holst.
Hef.
Ms. Slaughter?
Thank you, Your Honor.
Yes.
Investigator Holtz, can you tell us how you're currently employed?
Yes, I'm employed with the Cedar Rapids Police Department
And how long have you been employed with the Cedar Rapids Police Department?
since
If he is
2005.
a celebrate.
Are you a certified peace officer in the state of Iowa?
Yes, I am.
Went through one of the Iowa law enforcement academies?
Yes.
Fantastic.
What is your current title with CRPD?
I'm an investigator with the Criminal Investigative Division. I specialize in digital forensics, so I'm a certified forensic computer examiner.
And when you say that you are a certified forensics computer examiner, tell me how one becomes certified as such.
Well, first of all, it's a fancy way of saying I look for evidence in digital electronics, so it sounds kind of like a mouthful. But the training really isn't too bad. It's spread out over a couple of years. The first trainings that I go to are through an organization called the National White Collar Crime Center. That training provides.
He's gonna
locations
tell
throughout the
us
US where I
we
go and
found
learn the
all of the
basics and
evidence
intermediate and then
on
advanced,
his
type of topics
phone
when it comes to
or
digital evidence.
his computer.
And then I attended the International Association of Computer Investigative Specialists training. That's the certifying body for me. They're an accredited program, and so they certify me, and then I have to recertify every 3 years.
And where's that training that takes place when you're accredited?
That's in Orlando, Florida.
Did Dad have the
In your
ring app
professional
on
capacity,
his computer?
What type of cases do you generally work on with the Investigative Bureau?
I work on the Iowa Internet Crimes Against Children Task Force, which is part of a nationwide task force that involves child exploitation, child pornography types of cases. And because of that, I also have technical skills that apply to other types of cases, such as the one we're talking about today.
And how so?
I can examine any kind of electronics. And so even though my primary duty
Any
every
kind.
day is to look at cases that have to do with child pornography or child exploitation, if there's a homicide, if there's a robbery, a burglary, that type of thing, if there's any kind of electronic device that needs to be examined, typically that is left up to me to do that for the department and also for the surrounding communities.
Can you tell us if in your professional capacity you spend time dealing with a program called Celebrate?
There's a
Yes, I
device.
have.
Can you tell us what Celebrate is?
Celebrate is a company. They offer several different services. The
There's a
services that they
device.
offer at our department that we can actually use hardware and software. So they have hardware that can do extractions from phones, which means pulling the data from phones and other electronic devices.
I don't even know.
They have software
had
that
a thing.
processes that data because the data comes out in
I just
a bunch of
forgot.
language that we don't really understand. And so the software, they provide software that helps us look at that in a quicker way than we would if we did it manually. If we did it manually, it would take
So
months
basically
just
puts it
to
in a
examine,
spreadsheet
whereas
for
we can do
you.
an exam in a shorter amount of time with their software. They also provide labs across the nation where you can send electronics. So if it's something that we can't do in our lab, for instance, if it's a broken type of device, we can send it to their lab and they can help us with those types of things.
And did you receive specific training on how to operate and analyze data that you receive from Celebrate's programming?
Yes. So the training that I go through is they call it vendor neutral because Celebrate is just one of many companies that offers those types of services. And so we don't just have Celebrate in our lab. We have different types of companies that we purchase from. And so the training I go to is vendor neutral. It teaches the basics. And I always kind of explain it as they teach us how to do the long division without the calculator. And then the software that we get from either Celebrate or another company does the calculator stuff for us. And then we check it, check your math manually when we find some type of evidence.
When you analyze data that has been received after, I think we've commonly referred to it as a phone dump, when you're analyzing that information, is there a specific process or protocol that you go through every time that you analyze one of those packages of information?
Yes, generally there is.
Can you walk us through, let me ask that better. Specifically in regard to this case, did you look at the phone belonging to Alexander Jackson?
Yes, I did.
Did you look at that phone in an attempt to determine if a specific app related to Ring cameras had been installed or deleted from the phone?
Yes, I did.
Can you walk us through what process or procedure you went through when analyzing that information?
Yes. So, this case obviously happened a few years ago. And so the initial extraction of data, or phone dump as people like to call it, happens right away. And we use specialized hardware and software that extracts the data out, and then we process it using software. Typically what I do is I produce a report that is easy to see. You can click through it, you can kind of navigate through it sort of like a web page, and I give that to the investigators because they're familiar with the case and they look through some of that content. And then if they have specific questions, such as a Ring app or something else, then they come back to me and say, hey, can you use your training and experience to do a deeper dive on this application and find out more information? And so I first start with the software. The software has a roadmap to help it figure out what to display in front of me. And so it has categories along the side, kind of like a web page has navigation. It'll have categories such as application usage or media or internet usage, like power events, different things like that. So whatever you're interested in or whatever you're investigating, you can click on the side and it'll display it in a table in front of you. When it comes to media, it'll display a bunch of thumbnail images for us to look at, just like you would on the internet or on your phone when you're going through your picture gallery. That's the first step, is to look at data that way. And we try to use the software to narrow down what we're looking at. When we find something of interest, that's when the training that I've gone to kind of kicks in a little bit, is I have to make sure that that data being represented by the software is actually what it really is. Because otherwise, if I come to court and testify about it, that could be a really bad deal if the software is showing it incorrectly. And so what I do is I do an extra step of what's called validating the data. So it's forensically validating the data. And in other words, checking your math. In school, you might do a math problem and stuff like that and hand it over to your partner and they check it and they say, yep, you did it right. And so they're checking my work and I'm checking the software's work to make sure that it does it right. And so that's where the rubber meets the road, is you have to make sure that you validate the software correctly, because it can display things incorrectly due to, many times we get software updates on our phones. It happens all the time, actually, for my phone. It's always wanting me to update software and applications. So those can impact how the software works. And so the software that we use to look at the evidence isn't always correct. And so that's why we validate it.
During this deep dive that you did into Alex Jackson's phone, were you able to form an opinion as to whether or not that Ring app was ever installed and or deleted from this phone?
I have an opinion about it, but I don't know.
So yes, you formed an opinion.
Yes, I formed an opinion. The opinion is there's no evidence to show one way or the other. When we
Really?
and I'll go back to what I usually do every day, is I look at pictures and videos. If you find a picture or video, I can do a deeper dive on that picture and video and try to figure out, how did it get there? Did the user of the device, and is there evidence that they knew it was there, or did it just download on its own? That sort of thing. When something doesn't exist, there's no way to prove a negative. We can try. And what I did was I went into some databases and manually went through the databases, and manually went through the tables in the databases to look for evidence of the Ring app. And I didn't locate any. But the problem is that we aren't software developers, and software developers have proprietary ways that they program their software. And so the Ring app isn't going to tell you exactly how it interacts with your phone. And your phone is not going to tell you how it interacts with the Ring app. And so when I don't find evidence of the Ring app, I can't say with certainty, I can't testify with certainty whether it was or was not on the phone.
Was the
Which is
phone
kind of what the other guy
only
said,
device
right?
that you checked for the Ring application or accessing the Ring?
There was other devices in the home that we checked.
And what were those devices?
There was three other devices. There was a device owned by the sister. I'm bad with names. Some people might be like me, but I refer to him as the sister's phone, the dad's phone, mom's phone, and then the brother's phone. And so brother would be the defendant. And so I looked at the defendant's phone, and I looked at the other three phones, as well as a gaming computer. And then I attempted to look at a laptop computer.
And when you say you looked at mom and dad's phone, you did find evidence on those phones that the Ring app existed, right?
Yes, I did.
And you found evidence that the dad's phone had been accessed on June 13th of 2021?
Yes, and I have some notes I can refer to if you need exact dates and times, but that's correct.
And mom's phone had been accessed, I believe, June 12th of 2021, is that correct?
That's correct.
What about sister's phone?
I didn't see any evidence of the app on that phone.
Now you said something interesting. Well, you said you looked at a gaming computer, correct?
Yes.
And what's a gaming computer?
It really can be anything, but typically I label computers based on what I find on them. And what I found on this computer was it was a souped up computer, kind of like a souped up car, and it appeared to be used for gaming, which is really common these days. Lots of people have them. So it's like a tower rather than having a laptop or something like that. It's a tower. It has extra hardware inside that can handle graphics and things of that sort. And then there was also a lot of gaming information on the computer, which leads me to believe it's a gaming computer.
And then you said there was a laptop that you attempted to look in, is that correct?
Yes, I attempted to do an examination of a laptop that was found in the home, and I was not able to get into that actual laptop.
Were you able to determine who that laptop belonged to?
It appeared to belong to the defendant because it was found in the same area as the gaming computer. But without getting into the actual laptop itself, I mean, I can't say for sure who owns the
You
computer.
know, all of these things, and
far
people
as
still
who's
can't
scraping
break
user data
codes
and
to get
logins.
into
And you weren't able
laptops
to get into it.
and
I was not,
phones.
no,
Why?
It was encrypted.
What does that mean to be encrypted?
Encryption
Oh.
just means it's scrambled and you need a key to get into it. And so really it's more complicated than that, obviously. But really the simple way of looking at it is the data on it is all scrambled. It's in code. If you don't have the decryption key or you don't have the password to open the decryption key, then you can't actually access the information on the computer.
And so regarding the laptop or the encrypted laptop, you were, again, not able to confirm or deny, if that's the word I'm looking for. You couldn't tell whether or not Ring had been accessed from that laptop either.
No, I couldn't access any information from the laptop.
Couldn't get anything from the laptop. Stupid. Oh. Say sorry. That's loud.
Investigator Holst, as part of this investigation, you were, or were you the point of contact for the return of information after the execution of the search warrants?
What?
For the ring search warrants, I was.
For the Ring search warrants. Thank you for
Yes.
that clarification.
Yeah.
Investigator Holst, my understanding was that there were 2 different warrants served on the Ring company. Is that correct?
That is correct, yes.
In the second set of data, or the second attempt to receive data from Ring, did you receive information or any additional video clips in that second execution of that search warrant?
No, I did not. The return from Ring indicated that the devices were offline and there was no data available.
Do you know what it means for the devices to be offline?
Yes, I mean, they're not connected to
Wi-Fi
Ring's
was
network,
down.
so Ring can't communicate with them, and therefore information can't be exchanged from the devices to Ring where they store it.
Now why?
When the first search warrant was executed, in order for you to have received that information, does that indicate that the devices were online at that time?
Yes, when we receive information from Ring, we know at least during those times the devices were active and communicating with the Ring's network, because the search warrant is to the servers at Ring. They actually have the data. It's not stored on the devices themselves in the home. And so, yeah, we knew that they were communicating at that point.
To be clear, did you receive any information, though, that explained why that second attempt or that second execution of the search warrant, why the devices showed to be offline?
No.
Nope. Sorry about you. Slaughter.
I don't have any further questions, Your Honor.
Cross-examination, Mr. Johnston.
Hi. Investigator's fine, or you can call me Jeff. Okay. That's my
Turn your mic on.
That's the part that I do know, yes, is there was no data back from Ring on the second search warrant. That's correct, yes.
So all the cameras were offline then?
Whoa.
That's the indication that Ring gave us, yes.
Because I didn't see that anywhere in the report from Ring. So you're saying that you had information from Ring that when you did the second experiment for the 17th of June, that they told you that all the cameras were offline?
That's correct, and I communicated that to the team that was doing the experiment. That's why I said I only know about the data, I don't know about the experiment.
So that means all the cameras, the garage camera, right?
That's correct.
And the backyard camera
Yes,
and the front door camera.
correct.
All the cameras that were working on the 15th of June, right?
All the cameras that were hooked up to the network were were offline when we
We're
did the second search
offline.
warrant.
But they were online on June 15th, correct?
Yes, they were, because the cameras were online. I'd have to look at the data to say, but whatever Ring returned to us would have a date on it. So I don't recall I know that some of the cameras returned on the 15th, but I don't know if all the cameras were on the 15th. Does that make sense?
Sure. You authored an email, did you not, on June 16th of 2021? Actually, yeah, you sent to Josh McAlpin.
Yes, I remember that.
And who is Josh McAlpin?
He's a sergeant in the Criminal Investigative Division.
And you wrote, and this is with reference to the first search warrant on June 15th, right? You wrote, the backyard camera only has 2 motion activated clips, both around 6:30 Monday night. I am waiting on confirmation from Ring that these really are the only 2 clips, right?
Yes, that's what I was talking about, is I believe those clips weren't on the 15th, so that's why I didn't want to testify inaccurately.
Gotcha. Those were on the 14th, right? Those 2 clips.
From memory, yes, I believe so.
Other cameras have dozens of clips, including police activity after the 911 call. This angle doesn't. It is possible they didn't send all the clips, or the motion trigger is either set up differently to avoid picking up backyard animals, or is not functioning correctly, right?
That's correct.
That's what you wrote.
That's what I wrote.
And that's why you conducted this test on the 17th to try to see if there was something wrong with perhaps the motion detector, right?
That's partially right. First of all, I checked with Ring and they confirmed that there was only those 2 clips, because my email said, hey, maybe we just didn't get all of them. So I checked with Ring to make sure there weren't any more clips, and they said there weren't. I passed that along to the team that was doing the investigation. And then I did not participate in the experiment. So I don't mean to avoid your question, but I had nothing to do with that. So I can't really testify to that.
No, and that's quite all right.
Okay.
But I'm just saying that these were the possibilities that you brought up in
You know,
your
they
email,
could have had their
email to
motion
Josh
sensors
McAlpin,
off
right?
in the
Yes, that's
backyard
correct.
because there's a lot of trees back there, and if their motion sensors
And
are
the
so
reason
sensitive,
that you were all wondering about this is because on the 15th of June, all the other cameras showed police activity from that day, right?
That's what I remember, yes.
And the only camera that didn't even show the police in the backyard was the backyard camera, right?
That's correct.
Even though we know that the police were in the backyard that day.
Yes,
or
that's
they use the backyard frequently.
So it sounds like from your testimony that you would agree that there was no evidence on the defendant's phone that he ever had the Ring app on there, right?
That's correct. There's no evidence on the phone to say whether or not the Ring app was on there.
And you would also agree there was no evidence of the Ring app ever being on the sister's phone too, right?
That's correct.
Wouldn't that be entirely consistent with the fact that the parents set up these cameras and the kids didn't have anything to do with it?
Objection, Your Honor, that one calls for speculation.
Sustained.
So if I got your testimony correct on the, what you testified to about where you did find the Ring app, you basically agree with the person that we had review these, right?
I hesitate to agree to anybody that's been talking. I don't remember exactly all what he said. So
Well, okay,
if you can help me out, I can try to agree or disagree with something.
you said that the Ring app was last launched on Jan Jackson's phone on 6/13/21 at about 6:20 p.m.
I have a hard
I have
time
my
agreeing with
notes.
anybody
Yeah,
that's
look at
not
my
me.
notes.
Oh, please do.
Okay, sorry.
Please do.
Normally we don't look at notes, but with this kind of stuff, I want to make sure I'm accurate, and I can't remember dates and times that well.
We want you to be accurate too.
Okay, go ahead, sir.
So would you agree that the Ring app was last launched on Jan Jackson's phone on 6/13/21 for 47 seconds at 6:20 p.m.?
I've got it actually at 6:19 and 11 seconds.
Well, and wouldn't that be the camera photo that was at 6:19?
No, I've got a different time here. So
Okay, all right,
So
you're off. So you would disagree by a minute then?
yeah, I'm not trying to split hairs. I'm
No.
just saying
Oh,
I have
no.
from 6:19:11 seconds to 6:19:40 seconds. So that's what I have.
Okay, all right. Same date, 6/13/21,
That's correct.
and roughly at the same time.
That's correct. Yeah.
And did you note how long the app had been launched for?
Well, between 6:19:11 and 6:19:40, that would be how long the app was open.
So we had 47 seconds. You have a little less than that.
That's correct.
All right. And then, did you note that there was a corresponding still photo on June 13th from the backyard camera at 6:19 p.m.?
Yes, I have it at 6:19 and 16 seconds.
Okay, so you would agree with that too?
Yes.
And you would agree that the Ring app was last launched on Melissa Jackson's phone on 6/12/21?
Correct.
And did you have 8:55 a.m. for that one?
I have 8:53, but that may be incorrect. I'll go with what you say. That's fine.
And that was active for 24 seconds?
I believe so, yes.
And would you agree that the Ring app does not appear anywhere? We already talked about this, I think, but it doesn't appear anywhere on Alexander Jackson's phone, does it?
That's correct.
When did you do this analysis?
This analysis I looked at just over the weekend
Yeah.
because it came up through the prosecution. I had some questions. Typically, I would spend a little bit more time doing this, but over the weekend I looked at it, and that's why I have my notes here. It's in my head.
You obtained the Celebrite data, though. Now I want to be accurate.
That's fine.
On June 15th of 2021, right?
That's correct.
If you really wanted to know whether Alexander Jackson had used the app, they had that information back on June 15th of 2021, right?
Yes, I passed the reports that you can navigate through along to the investigators.
Not only did you have Alex's phone on Celebrite download on June 15th of 2021, but that's when you also had all the other family members' phones downloads available, right?
Yeah, we had all the downloads available within the same period of time, give or take a few hours.
Looks like from your police reports that you got them all on 6/15 of 2021.
That sounds right, yeah.
So you've had all of that time to do whatever analysis you wanted to do about the Ring app. The Cedar Rapids Police Department's had it all that time, right?
Yes, we have.
You could have done this analysis at any time between June 15th of 2021 and today.
That's correct.
And you did it yesterday.
I was asked to do it this weekend.
Would that have been yesterday?
Well, I think we talked about it on Friday and then yesterday. I don't recall, to be honest with you. I know I did stuff yesterday, yes, but the Ring questions started coming up, I think, on Friday, if I'm not mistaken, with the videos.
But it doesn't have to be a question, right? I mean, there are ways that you can investigate this that would tell you whether or not the Ring app was ever on Alexander Jackson's phone, isn't there?
I'm not sure what you mean, sir.
Let me ask you this question. And
And why didn't you look
back on
in?
June 15th of 2021, could you have got another similar model phone, downloaded the Ring app onto that phone, deleted it, and then downloaded the Celebrite data from that phone to determine whether or not it would still show that the app had been installed?
That would not be the way we would typically do things, no.
Well, how would you do it then? If you wanted to know if the Celebrite data was, if it could definitively say that something had never been on someone's phone, how would you go about doing that?
Well, that's the problem, is you can't say anything for sure when there's a negative like that. So if I were to do that experiment and if I were able to get the exact right software from Apple and the right, which is difficult, but I'm sure for a murder trial, we can somehow try to get that. And the exact right software from Ring, because they obviously have different version numbers, and the exact same phone, is still, all the variables still wouldn't be equal because of the way that phones work. I don't want to get into the weeds and the technicalities and confuse everybody, but phones work in the background. So things are happening all the time in the background on your phone, and we don't know about it. We don't see it. It's not part of the user experience. And so I couldn't replicate that experiment like you could in high school when you do an experiment where you have, a certain amount of one substance and a certain amount of another substance, and you try to mix them and that sort of thing. Well, you can't do a scientific experiment that would be conclusive by doing it that way.
But you would at least know if you did that, you could at least look at that data and say whether it showed up or not, right?
It's just not best practice to do it that way.
Well, I'm just saying, are there not ways you can examine that to see whether or not an app has ever been on somebody's phone and then been deleted?
That's what I'm saying, is that I've gone into the databases and manually gone through the databases to look for evidence of the application on the phone. And I didn't find any evidence of that. But what I'm saying, since I'm testifying in court, is that I can't say that the app was never on the phone. There's just no way I can testify to that. That doesn't mean I'm advocating that the application was on the phone. I'm simply saying I don't know whether it was on the phone or not. Now, if it was currently installed on the phone, yeah, we would be able to see that, of course.
I'm sorry, what was that?
If the app was currently on the phone, we would be able to see that. But I just can't say with certainty that the app was on the phone and then deleted, or if the app was never on the phone at all. There's no way I can testify to that.
I'm saying that if you conducted that experiment, at least you could see on that occasion whether or not the Celebrite download showed that the app was ever on the phone or not, right? You'd at least have that example.
It's a flawed experiment, so I wouldn't do it.
Yeah.
And there's no other way you can find that out.
No.
I mean, it is a flawed experiment. Given that it's 2 years later.
But what you did find was entirely consistent with the app never having been on Alexander Jackson's phone, correct?
No, I wouldn't agree with that. Again, I'm not trying to split hairs and be difficult, but I want to be precise when I testify. And no, I cannot say whether or not it was on the phone and then deleted, or if it was never on the phone, just like I can't say that with the sister's phone.
No, I understand that. I'm saying it's consistent. What you found is consistent with the app never having been on Alexander Jackson's phone.
I can't say that because the measure that you're trying to compare it to be consistent, that measure is unknown. Again, I'm not trying to get into the weeds or be technical about it, but I just can't agree to that.
I can say that I
I don't have any
cannot
further
tell
questions. Thank
you
you.
one
Thank you, Mr.
way or
Jackson.
Justice
another.
Slaughter, redirect?
No, Your Honor.
All right. Then investigator, you are free to step down and free to leave.
Thank you, Your Honor.
Thank you. Does the state have any additional rebuttal witnesses?
Sure.
State
ask
does
you
not
to-
have any additional rebuttal witnesses, Your Honor.
Any surrebuttal on behalf of the defendant?
No, Your Honor.
All right. So, ladies and gentlemen, every once in a while things go as I expect. And so I think that went kind of like I thought it was going to, and I told you. So what this means is we're done with the evidence in this case. we're going to let you go, as I indicated before lunch. At this point, there's some things we have to finalize and take up, and so that we're going to be in a position to, at 9 o'clock tomorrow morning, start directly with me providing you with the
Jury
instructions, most of them,
instructions and
we'll
then
close
closing
arguments, just
argument.
so you can prepare for tomorrow morning or for tomorrow. Once the case has been submitted to you folks, then we do keep you here during the day, right? So there will not be a lunch break tomorrow. I would anticipate you will get lunch. We will provide you lunch. If Terry is not already, she'll get a lunch order from you, but you will be here. You will not get to go home or leave once you've begun your deliberations tomorrow until the end of the day, or however long that takes.
Deliberations.
And you'll get further instructions. I just wanted to let you know that don't plan on a lunch break tomorrow. All right. So again, this case has not been submitted to you, so keep an open mind. You still have the law that you're going to get, and then the closing arguments of the attorneys. Keep an open mind. Don't make up your mind yet or any decisions. Don't come to any decisions in this case. Don't continue not to discuss this case with anybody. Again, avoid any media coverage of this case. And again, no investigation of any type or research about anything or anybody related to this case. And with that and the rest of the admonition, bid you a good afternoon, and we'll see you tomorrow ready to go by 9 o'clock.
Do we have anything exciting?
We can move to informal conversations.
Mr. Johnson?
Agreed.
All right. So, jury instructions. Couple.
No,
I think we
don't just
talked.
argue over jury instructions. No, I am not going to sit through that.
States 1 through 174.
Nope, 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 nope. I am not gonna sit through jury instructions. Well, that is it on this one. So that was fun. Defense has rested. State has rested. That was a very quick rebuttal. Whatever. They haven't convinced me. But let's hear their closing arguments, even though that's not evidence. That will surely give you more information. And we shall see. I don't know. This case it was okay at first, and then it just kind of, it did some weird things, and then it's just kind of like, I enjoy snark, but also at the same time, like, I don't enjoy temper tantrums. Like, the defense guy, Mr. Johnson, throwing a temper tantrum because you didn't like what the judge said about your stupid pictures. Like, bro, why are you going to put 148 pictures? Like, that's stupid. Why would you put 148 pictures? They're not going to look at them all. Would you look through 148 pictures? Especially if there's multiple pictures of him holding a flute and in a Boy Scout uniform. Who gives a shit? Show me a couple. That's it. Show me one. Shit, I don't need to see multiple. I definitely don't need to see him as a baby. I see him now. And really what I'm going to look at now is I'm going to be like, he doesn't look the same. Definitely his mugshot definitely don't look the same. I don't know. Just, how are you going to sit there and throw a fit over 148 pictures? You wanted to put 148 pictures. You're going to sit there and bore out of spite. I say guilty. You're going to give me 148 pictures to look through. Get the fuck out of here, bro. I don't know. The state was just weak. State's weak. But juries are stupid. I would really like to know. Really like to be in that jury room. I would. Okay. I got a little pup here that needs to go out. I can't say it too loud because then she gets it in her brain and she thinks she can just go. Okay, well, I gotta take that one. And so, yeah, let me know what you think. Because, I don't know. State didn't convince me. State didn't convince me at all. They would not like me in a jury room at this point. Because it would be a hung jury. If there were other people in there that thought I was guilty. And they all wanted to be like guilty. I'd be like, You said beyond a reasonable doubt. There is reasonable doubt to believe that something else could have happened. Not saying that he didn't do it, but I'm saying the state was lazy as fuck. And I'm not going to give it to him. Just like in this Murdoch case. It's just lazy. Like, so far, I ain't seen nothing that has been like, good police work. They did good. Good job. Nope. See? She wants to go. Okay. Like, comment, subscribe. Let me know what you think. All of those things. And yeah. Okay. I shall see you on the next one. Bye.